2017 meeting of the New York City Campaign Finance Board. Our first order of business will be approval of the minutes from the December 15th, 2016 board meeting. Do I have a motion to approve the minutes?
So moved. Second.
Second. All in favor?
Aye.
Aye. And the minutes are approved. This is the Campaign Finance Board's first meeting of the new year. So before getting started, we have a number of announcements in anticipation of a busy 2017. The mayor has called a special election for City Council District 9 in Northern Manhattan, which will be held on Tuesday, February 14th, Valentine's Day. Candidates interested in running for the seat face some pressing deadlines. Most importantly, the deadline for candidates who wish to participate in the campaign finance program is Tuesday, January 17th. In order to submit a certification form to the CFB, that's only 3 business days from today. Forms delivered to the CFB by hand must be received by 5 p.m. on Tuesday, and forms submitted by mail must be postmarked before midnight. Ahead of the special election, the CFB's voter assistance staff is registering voters and making sure everyone eligible to participate has the opportunity to do so. Since the election is being held on Valentine's Day, we encourage voters to bring their loved ones with them to the polls, and you can get them a really nice I voted sticker. Today also marks the initial day for candidates in the 2017 citywide elections to file the first campaign finance disclosure for 2017. All 2017 candidates are required to submit their filings by January 17th. The CFB will publish those financial disclosures to our website as candidates provide them. I now turn to Executive Director Amy Lopez for her report. Amy?
Okay. So as Board Member Piazza said, we are getting ready for the elections, both the special election in February and the 2017 election. And one of the things that we are doing is improving our technology. And as I announced in the summer, we introduced a new application called NYC Votes Contribute, which allows candidates to solicit and collect contributions through credit cards, and it provides all the documentation that is required for those credit cards, and the disclosure, it can be seamlessly uploaded into our C-Smart software. That has been very successful. There has been collected, since that was introduced in the summer, about $950,000 in contributions. The average contribution size is about $181. And I'm happy to note that that has really ramped up. In fact, there was collected in the last 24 hours before today, $143,000 in one day. So, definitely candidates are making use of that tool that we have made available to them. In addition, in December, we rolled out a revamped C-Smart, which has a new user interface and is much more user-friendly, and hopefully candidates will find it easier to use. This is the first disclosure statement with that, so we will get some feedback from the candidates after this disclosure statement is completed. Finally, I just wanted to note that this week, Governor Cuomo introduced a package of voting reforms, including automatic voter registration, same-day registration, and early voting, items that we, through the Voter Assistance Advisory Committee and our NYC Votes and Vote Better NY campaign, have been urging over the past couple of years. And again, we urge the state legislature to pass these reforms to make voting as easy as possible in New York City to hopefully increase voter turnout.
Thank you, Amy. And we have one candidate appearance today, and that would be the Yetta Curlin campaign. You can step up.
So as you step up, I'm going to explain what's going to happen. The staff will give the board a summary of the issues that are before the board. I want to assure you that the board has been given all of the responses and documents that have been submitted by the campaign previously, so there's no need to reread those. The board has all that information. What is going to happen after the appearance is the board is going to go into deliberate, and I asked if you could stay in case the board, when they come back into public session, has additional questions for you. This is our this is a new procedure, so I normally I would say you could leave, but the board might have additional questions that have to be answered in public session. So if you could remain and then the board, if they don't have any questions, the board will vote on this and other matters that they have.
Just glad we're the only candidate. Lucky word.
Yeah, last month would have been more of a big ask. Okay.
Hey, good morning, everyone. My name is Danica Yu, counsel for the board. With me is Hormus Taliath. He's one of the CFB auditors. Before the board is a matter of the Yetta Curlin campaign in the 2013 election for City Council District 3. The candidate was a participating candidate in the program and received $92,100 in public funds. CFB staff recommends that the board find the campaign committed 9 violations of the Act and board rules based on failing to provide bank or merchant account statements, failing to report transactions, failing to demonstrate compliance with reporting requirements for disbursements, accepting over-the-limit contributions, accepting contributions for corporations, limited liability companies, or partnerships, accepting contributions from unregistered political committees, failing to demonstrate that spending was in furtherance of the campaign, making impermissible post-election expenditures, and exceeding the expenditure limit by 4.64%. The campaign contests these violations. Also before the board is a recommended public funds repayment obligation of $1,444.81, which is simply based on the campaign's final bank balance as of July 31st, 2016.
Thank you.
And if you could just state your names for the record.
Sure. I'm Leo Glickman. I'm the attorney. I was also the treasurer for the Curlin campaign. Good morning.
And my name is Yetta Curlin, the candidate.
Happy New Year, and Happy New Year to you, Amy. Nice to see you. We just want to, first of all, I actually want to thank Danica and Hormus for engaging us in this process. They have been tough but collaborative, I would say, and I really do appreciate that. Thank you. There were actually more issues after the first notice of violations that we were able to sort of work out, and we appreciate that you worked with us on that and were able to resolve them. I'd like to first discuss, I kind of want to discuss this in terms of sort of issues that sometimes cross-violate, that implicate more than one violation. And so the first one I would like to discuss is the reporting of transactions. In violation 2 and 3, it's alleged that we did not report all of our transactions, and we're being subjected to a penalty. And I just want to explain, so that's a portion of number 2 and all of number 3, I believe. And in that case, it just needs a little explanation. We received the draft audit report. On that draft audit report, it tells you that there's certain transactions which don't appear to have been reported correctly, others that were reported that seem not to have been reported, and then still others where you reported something that doesn't seem to appear on a bank statement, so perhaps they need to be deleted. And we went through that process in normal course of the draft audit report and took care of them all, except that we apparently did not submit the transactions that I had entered, the new transactions that needed to be entered into CSmart as part of the audit report. And the reason is this: when we were responding to the draft audit report, we did enter all the information, and I think that's not going to be disputed by the general counsel, but by the council. But when you do in CSmart the modified report, what you see, what it tells you is all the statements that were amended, and then that's supposed to help you know which reports to submit. So we did that, and we did that normally, and I don't think there's no issue with that. But the new transactions, even though they're dated for prior disclosure statements through the campaign, actually don't amend those statements, but are submitted separately in the final statement to the Campaign Finance Board. That's how that works. Now, I didn't realize that, frankly. So we had not resubmitted the final statement. Now, that final statement, even though it covers a period of sometime in September to 2013 to January 11th, 2013, but that includes all these transactions that were from statements well before that I thought would have been included in the amendments. So, as proof of so when we got the notice of violation and I saw this, and I realized what had happened, and I asked them, and they told me, I submitted it immediately, but apparently your system, once a notice of violation is issued, your system doesn't accept that. But as proof of that we actually did this work, it just didn't get submitted. We submitted to Danica and Hormuz the screenshots of those particular transactions that were entered.
Let me stop you right there. A quick question. You said you did the work but did not submit them? I thought you did submit them but failed to resubmit.
We don't know.
Dana, can you sort of clarify that actually?
You have me confused now.
It might be helpful for me to clarify because I can tell you, just to properly explain, submit means that the staff would actually be able to see it. So based on what we can see, it appears that the campaign had entered the information into CSmart but never hit the submit button. So nothing was submitted or resubmitted.
But nobody could see it.
No one could see it except for the campaign on their own computer. So it was never disclosed publicly because the submit button was never hit at any point in time. Otherwise, would have seen it.
So we could call that user error.
It is a user error, and I don't. CSmart is mostly very, very good, and I don't want to get into a whole. But when you run this report, I honestly just didn't know that. I figured the transactions from the particular dates would amend those statements and that it would be submitted that way instead of them being considered. And they are new transactions in a sense. I get that, but they're not new in the sense that they came at the time of the last statement. So I thought they would have amended those, and we ran the amendment and the amendment report, submitted all those amendments, but it does not list the one that has to be resubmitted, and we didn't do that. And again, so it is a user error, but it's not entirely clear is all I want to say from CSmart. So and that's why it didn't get submitted. But we did prove that at the time when we were responding to the draft audit report that they were, it wasn't submitted timely. Of course it wasn't, but they were entered at that same time when we did all the others, and it just didn't get submitted. So we ask that, the board consider that with these particular two violations on that.
Can I ask you
Sure.
It's a detailed question. There are, under item 2, there are two failures to report. The first is transactions in disclosure statement 16, and the second is personal contributions. Are the facts that you're stating here applying to both of those categories?
No, just the first.
Just to the first.
Yeah,
okay.
and we will get to those personal contributors because that has an effect. Yes, but we'll get to those.
And I just want to clarify because we actually did an analysis of the screenshots versus the unreported transactions that we have listed, and there are $902.14 in payments that are on our unreported transactions exhibit that were not on the screenshots. So it's almost all of the transactions except for the $902.14 in payments to card payment services, a $1,333 unreported in-kind contribution, and then the personal candidate contributions. So everything else was accounted for except for those items.
Okay, and do you both agree on those numbers?
I actually don't know. We haven't, we gave them all the screenshots. You guys said you received it. I thought that covered everything. But we haven't talked about it since I gave it to them. So I don't want to say that it's possible that something's not included. And I think I also said that there was one or two items that wouldn't be included because they were, I don't know if that incorporates that. Well, I mean, the thing is, it does incorporate that.
Well, which ones?
There was the contribution refunds that were not. that wouldn't be reported.
No, those are not included. Yeah, this is
I didn't
solely
think-
everything else that
Okay.
should have been reported.
Right, because
that
you
we
understand
agree.
when the contribution, you can't because.
No, I understand. That's not an issue.
Okay, fine. So honestly, I don't know. The staff may be correct about that. I mean, that represents about 7 or 8% of the total, I would say, that we're talking about here. So I don't know.
Can I just ask a question about what it says in the draft audit report about reporting and filing the amendments? Does it mention filing that if you add new transactions, you were to file statement 16?
In the draft audit report, my understanding, Hormus, you should correct me if I'm wrong. The draft audit report explicitly says that they have to report these unreported transactions as new transactions because they were never reported to begin with.
I believe that's correct.
So the campaign had the opportunity at the DAR response to submit all of these unreported transactions.
Right. Yeah. I mean, I don't remember exactly what
No,
it
no,
says
no,
from
no,
a
no,
couple
I
years
understand.
ago. I'm sure it does say new transactions, but it doesn't say,
File statement
that it's
I
a
understand.
resubmission.
Yeah.
Like logically, I understand that sitting here now, but at the time that's
I understand.
okay.
I just wanted to know what it said. Okay.
Okay.
And what about the personal contributions?
I was planning to get to that a little later. It would be a better segue, but I can do it now if you would like.
Yes,
Okay.
I would.
Okay. The personal contributions. Well, first, I mean, there's a few. Let me sort of deal with a couple of sort of technical issues. One of which is that Ms. Curlin made a $125 contribution to the New York County Committee, which is being included in here as an unreported personal contribution. And that was made on November 18th, 2010, which was before she was a candidate, frankly, before she was thinking about being a candidate. And I could say that because she talks to me about whether to be a candidate or not. And she hadn't talked to me about it at all at that point. And in fact, and I understand, we don't really have to deal with this sort of metaphysically. The law and the board's rules make it very clear that you're a candidate when you start, not when you're petitioning or not when, you appear on the ballot, but when you start raising or spending money. This still predates when she was raising and spending money by about 10 months. What
was the date of that contribution?
November 18th, 2010. And she did not start raising or spending money for the campaign until August 2011. So, we think just under the terms, I mean, the final board determination that we were operating under in this election, refers to candidates making these contributions, and we don't believe she was a candidate at that point. So that's one, $125, and then we're on to the 2,000 or so.
And I just want to clarify that for purposes of determining whether contributions made by a candidate are applicable to the 2013 election cycle, we began counting in January 2010 through Election Day.
Now, as to the rest of the contributions, the final board determination states that a personal contribution to a political committee must be reported, and this is a quote, unless the candidate shows that the contribution was not in furtherance of his or her campaign. I mean, that's the board rule. My understanding is that the board sort of interprets that sort of for auditing purposes to mean that if you had this lengthy history of giving to the political committee, that might defeat the presumption that it's in furtherance of your campaign. And that seems like that's one good factor to look at, but I think there are many other factors to look at here, and I think that we've described other factors. I think, what we have shown is that all of her contributions were not remotely meant to be in furtherance of her campaign because, in fact, these political committees do not make endorsements in primaries, do not make, in the case of Eleanor Roosevelt committee, they do not make, not only do they not make endorsements, but they're not allowed to support candidates in Democratic primaries. So, there was nothing other than, and I think Ms. Kurland will explain a little bit more, but, these are people who are friends of hers, or in the case of Eleanor Roosevelt especially, a very a contribution that was made for an issue that was very close to her heart, which she'll explain. But we do think that, we have defeated the presumption that it was in furtherance of the campaign. We have produced to staff, and you should have it, bylaws, screenshots of the websites that show that in each of these cases, these are not organizations that not only do they not endorse, the individual members are not allowed to support candidates in Democratic primaries. And so there must have been other reasons why Ms. Kurland made these contributions, and I'll let Yetta talk about it.
Sure. Hi. Good morning. And again, thank you for taking time to listen to us. And, I just want to start by saying I really appreciate the work of CFB. This is my second campaign that I ran. It was a incredibly unique set of experiences and a unique situation. When I ran in 2009, I was very happy to say that all of our submissions to the CFB were, approved, and the audit went through with absolutely no violations whatsoever. And I am the candidate. I take full responsibility for my campaign, but I do think there's maybe some explanations that I think are important, and we would ask that the board consider generally. In specific to your question about the personal campaign expenditures or what are being deemed expenditures. For example, the Eleanor's Legacy Fund contribution, that was a event to celebrate what had just been a decision in the Edie Windsor decision, which allowed for same-sex marriage. And that was a huge deal to me, to many. That is why I went to that event. The person, in fact, there's a picture on the submission that you have that's one of my dear friends is actually introducing Edie Windsor. I know Edie Windsor personally. That was the motivation for attending that event. It was not in any way, there wasn't even a capacity to do any kind of work related to my run for city council. In regards to another event, it was that
was for $1,000, right?
Yes, it was $1,000. For the Manhattan Young Democrats, again, I absolutely knew that they were not endorsing. It was not in furtherance of my campaign. My good friend was at the time the president of the Manhattan Young Democrats. She asked me to attend the event. I said I would. Likewise, there was, I believe, another.
The friend was Kim Muscaritolo.
Yeah.
Yeah.
That's okay. There was, I think, another dinner. Again, it was like a county committee dinner. I was asked to attend, to buy a ticket. I bought a ticket. I went to the dinner. It wasn't part of any kind of orchestration or any kind of I knew very clearly that those were entities that actually weren't going to be endorsed and weren't involved in my city council run. So.
Yeah, and I'll just note in terms of the county committee donation, Ms. Kurland does actually have a past of giving to the Democratic county committee. Perhaps not lengthy enough to satisfy the staff, but she has given in the past. So we also sort of add that to the mix. So, again, I just can't emphasize enough look, this is Council District 3. The election was the primary. I mean, was there a Republican in the race even, or?
I think that there was, but
whoever was going to win the Democratic primary was going to get the support of these organizations, period. And they specifically and adamantly do not make endorsements or support candidates. So, the staff has said, look, even though they don't make endorsements, they can still, there's other ways to support candidates. I suppose that's true. We just disagree in this case because we believe that, their bylaws prevent them from doing so. And in fact, they didn't do anything because they wouldn't either for Ms. Kurland or her opponent.
I guess I would say one other thing, which is like, I am a very civic-minded person. I'm very involved. I tried to be involved. Running for office was an experiment in doing that. So I just am involved in organizations. And so that means going to events. It means buying tickets to dinners. That's just something that I do in my life and try to do. And,
And just the final legal argument I just want to make here is that, this new rule, this rule was for 2013 is included in something called a final board determination, which respectfully does not actually carry the rule of law, so to speak. The CFB is authorized to issue advisory opinions, obviously to promulgate rules, and of course to administer the law, the act. That's, as a lawyer, when I'm restarting up and say, what's been the CFB been doing the 2 years when I haven't been paying attention? I go through, when you have the rule updates, I go through the advisory opinions. And so I understand this isn't a final board determination. We're not going to challenge that in court or anything, but I bring this up only to say that that this is a little over $2,000 in contributions, which is now going to her expenditure limit, which at this sitting here right now is costing over $3,000. It's a little harsh to me, considering that this rule is really not included until recently, until after the election, in your rules or in the act or in an advisory opinion. So we also, we ask that you just consider that when you're considering this in executive session.
Yeah, I just want to clarify. I mean, under the Act and Board rules, the board certainly has the authority to clarify certain points and establish guidelines, and whether it be a final board determination or an advisory opinion. And they carry weight, and they should be acknowledged by the campaigns.
We agree. The law says that you have the authority to issue advisory opinions and promulgate rules.
And it also gives us the broad authority to issue rules and issue determinations, which includes this one. I'm not going to go further with it. We clearly disagree, but I just wanted to get that on the record.
I just want to say this, though, but when you issue
I think we're all familiar with the law and how the rules. We've been all sitting here for
many years.
And Naomi's joined us, and I'm sure she's up to date.
Yeah, I just wanted to say that for the record to make sure.
But can we move on to number 4, the accepting over the limit contributions?
Before we move
Naomi,
on,
I'm sorry.
I just ask a question? You had referred to the November 18th, 2010 contribution to the New York County Democratic Committee.
Mm-hmm.
My understanding is that was not included as one of the unreported transactions, but was simply used in the effort to determine whether there was a lengthy history. Is that correct?
No, it's actually one of the unreported contributions because it was not. It's unreported, and it was made on November 2010, which is when we started beginning counting personal contributions towards the 2013 election cycle.
Okay. All right. Thank you.
Okay, if we can move on to number 4.
Sure.
That's accepting over the limit contributions.
Well, all we have to say to that is that, the board acknowledges that we did return that timely, and, we ask that be considered when you're considering the penalty here.
Okay, and then number 5, accepting contributions from corporations, limited liability
Okay.
companies.
Well, on this, the rule that's sort of an issue here is Rule 104E, and it states that candidates may not accept contributions from a corporation, LLC, or partnership. And we we say and we submit that we did not do that. We submitted documentation which shows that in these two instances, these people do personal business and their business out of the same account. They are professional corporations. We acknowledge that. I will say that in past election cycles, it has been that documentation proving that there was personal funds to cover the contributions was encouraged, that documentations, and permitted to show that the contribution itself was not a corporate contribution. I'll only say apparently that has changed, but it's not reflected in a rule change or an advisory opinion from what I can see. And again, so I unless I'm missing something. So again, we did do that. I understand this interpretation of the CFB, but I also understand that it is a departure and a change in practice from prior election cycles, and we ask that that be taken into account.
There has been no change, as far as I know, from past election cycles. When you're dealing with a PC, it is a professional corporation, and a professional corporation is a corporation.
There are people probably sitting in the room who could answer that question, because I'm quite certain that
we do encourage that when it's dealing with other types of business and business and personal accounts. But when it's a corporate account, it's a corporate account.
In this campaign, in 2009 we actually did that. So I'm quite certain. I mean, I've been doing this in many election cycles now, and there is, in fact, a document that allows you to do that, and it's been accepted in the past. So,
Okay. Let's move on.
I'm sorry, what are we on now? Six. Okay. This is the political committee. So I just want to say this. Yes, we accepted this contribution. As the board and staff knows that, if a political committee registers within, is it 10 or 20 days?
10 days.
10 days after the contribution is made, then it's sort of a safe harbor. It allows you to keep the contribution and it's legal. We in this case, we took it, we accepted, we looked it up. They weren't registered. Personally, I remember having the conversation, bring this form over, hopefully they'll do it, and they didn't. And so they didn't, and then we returned it. And I think that's also been acknowledged that it was returned. But, we're now being penalized for that. And we just say to the board that there's this pressure. On the one hand, you do have the safe harbor provision in the law. There's also the board strongly recommends that you deposit your checks as quickly as possible. So we're depositing the check. We're hoping to get the registration form. We don't get the registration form, and then it gets timely returned. So again, we ask you to consider that that's the circumstances of that contribution.
Okay. Number 7, that's a refund to Amy Monroe.
Well, I think we're just going to, it was a mix-up in the campaign. We refunded something twice, and it was a mistake. So there you go. I don't know what else to say about that. All right. So
she had given an amount over the amount she could because she was doing business.
It was a doing business contribution. So, and then we mistakenly refunded it twice.
And then she went on, I think she donated like a $50 again. So we refunded the $750, and then we refunded $800 when we should have just refunded $50. So.
Okay. I'm sorry, where are we now?
Number 8.
Sorry, just give me a moment.
It's the impermissible post-election expenditures.
What's that?
The impermissible post-election expenditure section.
All right. Yeah. And on this, the post-election expenditures we're talking about here is just keeping our accounts open during this audit. There was a possibility we were going to have to refund money or accept money from contributors and vendors, and also, we're keeping it open. Depending on what sort of happens here, we may need to raise money. We don't know yet. And I think that relates to that. And that's why we're keeping it open. And we kind of feel that should be considered permissible, so that's our view.
Thank you. And number 9.
I'm sorry, can I ask a question just about one of that? One of the transactions in the improper post is a payment to Westview Incorporated for $600. So most of them are along the lines. Is that also just an account keeping open? I just wanted to.
They might be able to answer better. I Googled what Westview Inc. was, and it appears to be a West Village newspaper. So that's not, that wouldn't be considered a fee for a bank. It would be an expenditure.
January 24th,
I'm sorry.
2014.
I thought all of these related to.
No, there's one $600 expenditure. It's on the exhibit that lists all the impermissible post-election expenditures.
So
it was a check that was.
So there's one for 600, and then the rest of them are.
The rest of them appear to be bank related.
I have to say I missed this. I apologize. I actually don't.
Okay, fine.
Did I not respond? Did I respond in our?
No. Okay.
And number 9,
Okay.
exceeding the expenditure limit.
Well, we've spoken as about 2125, I think it is, relate of expenditures that were challenging relate to the personal contributions that we made. We think we've covered that. Obviously, if you have more questions, that's fine. In addition, we haven't had, last night going over this stuff, I noticed this, and if you don't mind, if I could just ask you, we haven't talked about it, but from the expenditure limit calculation that we got from you on July 29th, 2015, and to the last one, which I believe, I guess is June 24th, 2016, our 2013 prior year over the limit went up by almost $500, like went up by $495.29. And I apologize to the board. This would be a good thing for all of us to work out before we get here, but I literally just noticed this last night. And I'm not sure, I don't know why that is. I don't even know whether or not to challenge it. I just point that out.
Just give Hormus 1 second. He'll take a look.
Again, I apologize. It should have been dealt with earlier.
But let's talk about the advanced group while we're
Why don't you
While
move
they're
on?
looking.
Yeah.
Okay. I'm sorry. You want to say? Yeah. Can you just to go back, just to answer the Westview question?
Oh, okay.
As I remember it, Westview ran an ad for us during the campaign. There was some question over whether we had actually ordered the ad or not or whatever. They sent us a bill after, and we paid it because they claimed that we owed it. And I think they provided proof that an ad had actually run. I don't know that we actually ordered it or had confirmed the order or knew that it was being charged, that was happening. But because it ran, we then paid.
And was the backup documents provided to the CFB?
No, we didn't receive them. We don't have anything from Westview. I just did an online search because I was curious.
I could probably just Google the ad if you wanted to see that. It's probably online as well.
And I apologize. I don't really remember this.
At this point, staff has given the campaign many opportunities to provide documentation. So what we have is what we have. If the board would like to accept anything, that's up to them.
Mr. Glickman, if you could address the advance group.
Sure. So I'm going to let Ms. Kurland talk about that because she had the privilege of working with them the most, and I think can speak about it more authoritatively.
So as I understand, the issue is that because we had to terminate our agreement with the advance group and hire someone to replace them, assuming all of those payments to the advance group and the second consulting firm were included, we would be over the spending limit. So I just would say that first, as you can see in the terms of the agreement, as well as the correspondence most certainly that work was not completed under the initial agreement. And we were forced to hire a second consultant to do that work.
Mona Davis.
Mona Davis, right. Setting aside the adverse impact that had to the campaign, certainly we would ask that the monies that we had to pay to the advance group not be counted towards our expenditure, because in essence they were not in any way provided. And when we learned when we realized that was happening, we spent a lot of effort trying to resolve that. It is a very sensitive matter when you are on a campaign and dealing with something like that. You have to be diplomatic. You don't want it to cause more problems.
But you paid the advance group $27,000. You disputed the bills in 2012, but never followed up.
Well, first, that's not the case, I don't think.
Well,
but let me just, I'm
There
sorry.
was an agreement to enter mediation. So you dropped your challenges, your dispute of the bill, but the mediation never took place.
The mediation did not take place. And first of all, let me just say, for example, let me focus on one particular $4,000 payment. We had a contract with them to go through the end of the year. Also,
I would actually like to focus on Mr. Piazza's question, which is, why didn't the mediation take place?
they did not enter.
They wouldn't.
They wouldn't do it. And
Do you have,
because they wouldn't do it, I mean, is the answer. And
even though that was contractually required?
There was a lot, all of it was contractually
I
obligated.
understand, but the dispute resolution.
that's
So
correct.
was there any other legal effort to try to recover the money?
Right, and that's what I was about to answer. Look, while the campaign was going on, the advance group is a very politically wired consultancy, and I mean, I have to say, I'm like, this is all, the number of conversations that we had about this, because frankly, we're mad as hell, and we really wanted to do something about it. On the other hand, we were concerned that he had the ability to actually, turn potential endorsers against us, and that was a concern going on throughout. Now, we had made, I just want to get, I'm sorry, please, go ahead, Mr. Chen.
And I totally understand that, and you have other priorities, and the candidate had other priorities. But the question is, once the primary was over, these are public monies, and why wasn't there an attempt in the post-election period to do the necessary paperwork and legal work to actually at least make a valid effort to recover that money?
I understand that. First of all, and this is something I'm frankly, very uncomfortable speaking about in a public forum, but there was a criminal investigation going on that of my understanding that the advance group was the target. Can we just have a moment? Again, this is just because this involves criminal investigation, and one moment. And frankly, we were asked to cooperate and did cooperate with the authorities to do that. And
We don't know
we actually don't know at this point if it's still ongoing or not. And we really could not have interactions with his office or him personally. So that sort of was driving a lot of this post-election, because we started to be asked these questions actually right after the 2013 primary was completed. It was, I think, in November. So that was going on, and I don't know if it's still going on or not. And so there's that. And frankly, Mr. Chang, the last thing here is that this is going to be a dispute. At the end of the day, I totally understand the board's position. This is public money, right? So we should be trying to get it back and reimburse the public money. And I do respect that and certainly understand your position on that. And you're right. The issue is also though, for the amount, I can't even tell you how many records are involved here, and thousands of pages of emails that are going to become the subject of a lawsuit, to recover, we're not going to recover all of it, to maybe get a few $1,000s. So, I mean, frankly, just as a person from my end, I'm thinking about that too, spending all of this time. And it's something we are still thinking about that's open, but, these are all factors. They're just sort of practical factors that we're discussing amongst ourselves.
And maybe I don't know, and I apologize, but maybe the campaign finance board has more power and authority and direct ability to recover that. I don't know if you're able to do that directly or not. But
Okay, thank you.
The other thing I'll say is, while I was aware that the work wasn't being done under the four corners of the agreement, and that we weren't getting the services that we had requested and contracted for, I was not aware until later that the advance group was also working for my opponent. And that's what we were, the diplomacy and the trying to tampen down was to avoid things like that. And,
And I just want to say, to focus on just one particular payment, the last $4,000 this was our way to show, look, we'll keep you on for another month. We're paying you this. Don't do anything except don't disparage us. Don't work for our opponent. And if we get a message, forward it to us. And that apparently was not happening, which we didn't have particular knowledge of, but it's been reported in the press that actually his company was helping our opponent. So that's one particular payment that we want to challenge, but for the reasons we have not yet.
Okay, thank you. We'll now take a look.
The open question about the.
Oh, I'm sorry, we have one open question.
Yeah, so with the question, we don't have the specific documentation he's referring to in front of us because it's from 2012. Our first inclination is that it may not even impact this calculation. We're going to speak with them to make sure while you're meeting, just to confirm.
Talking about the 495.
Correct. Yeah, so I don't think it actually even, we just need to confirm that that's factual. And then if it does, we don't think it impacts this particular portion of the calculation, but we'll confirm.
Okay, do we have a motion to go into deliberations to vote on penalties and repayment? So second, all in favor? Aye.
Aye.
Okay.
Thank you.
Ready? Okay, the January 12th, 2017 meeting, Campaign Finance Board is back in session. And we went into deliberations to vote on penalties. I guess I'm reading them? Or?
No, I can do it.
Okay.
Okay.
So I'll turn it over to Executive Director Amy Loprest.
Okay, so first we have candidate Benjamin Kalos, candidate in City Council District Number 5 in 2013, filing a late disclosure statement, a violation, no penalty, accepting over the limit contributions, a violation, no penalty, making impermissible post-election expenditures, $183, exceeding the expenditure limit, $3,244, using campaign funds for inaugural expenses, a violation, no penalty, for total penalties of $3,427. Next, we have candidate Yetta Curlin, candidate in City Council District 3 in 2013, failing to provide bank and merchant account statements, a violation, no penalty, failing to report transactions, $125, Failing to demonstrate compliance with reporting requirements for disbursements, $125. Accepting over-the-limit contributions, $125. Accepting contributions from corporations, limited liability companies, or partnerships, $275. Accepting contributions from unregistered political committees, $125. Failing to demonstrate that spending was in furtherance of the campaign, $187. Making impermissible post-election expenditures, $172. And exceeding the expenditure limit, $11,704, for total penalties of $12,838. Next, we have candidate John Liu, a candidate in the 2009 election for controller, accepting 5 corporate contributions, $1,125, accepting 8 contributions from unregistered political committees, $2,000, accepting 31 over-the-limit contributions, $6,375, accepting 16 over the limit doing business contributions, $4,250, failing to provide bank account and merchant account statements, $300, failing to provide signed intermediary affirmation statements, $200, failing to report daily pre-election contributions in excess of $1,000 and expenditures exceeding $20,000 during the 2 weeks preceding the election, $300. Non-campaign related expenditures, $103. Improper post-election expenditures, $600. Total penalties of $15,253. And finally, we have candidate Mark Traeger, candidate in City Council District 47 in 2013, accepting a contribution from an unregistered political committee, $250, failing to demonstrate that spending was in furtherance of the campaign, $2,500, making impermissible post-election expenditures, $100, for total penalties of $2,850.
Okay. And do we have a motion to approve the penalties?
So moved.
Second?
Second.
Second.
All in favor?
Aye.
Aye. And now the repayments?
Okay. Repayments, we have candidate Benjamin Kalos, candidate in City Council District 5, $506.56, which represents his final bank balance. Candidate Yetta Kurland, candidate in District 3 in 2013, recommended repayment of $1,444.81, which also represents the final bank balance. Candidate John Liu, candidate for controller in 2009, repayment of $9,035, and candidate Mark Traeger, candidate for City Council District 47, $2,750.
Do we have a motion to approve the vote?
So moved.
Second.
All in favor?
Aye.
Okay, if we can have a motion to adjourn into executive session.
So moved.
Second?
Second.
All in favor?
Aye.
We'll now move into executive session. Okay, the January 12th, 2017 meeting of the New York City Campaign Finance Board is back in order.
Okay, the staff is recommending that the board dismiss a complaint against candidate Yetta Kurland, candidate in City Council District 3 in 2013.
We have a motion to dismiss the complaint. We have a motion? Second?
Second.
All in favor?
Aye.
Aye.
Okay. Finally, the staff is recommending that the board delegate the authority to approve payments for this in a period that need to be made when the board is not in session to the most senior member of the board. Those payment approvals would be ratified by the full board at the next following board meeting.
That's in the event there is no chip.
That's in the event because there is no chair. The board had delegated that authority to the chair of the board, but there is no chair at the moment, and we will be needing to make payment determinations for the special election.
Okay, do we have a motion?
So moved.
Second.
All in favor?
Aye.
And we have a motion to adjourn.
So moved?
All in favor?
Aye.
Aye. Thank you.